Hey everybody, welcome back to the Court of Random Opinion. I'm here with my friend Omar the Tilted Lawyer. My name is Lord Neidigh, and we're going to talk about some of the what the.
Yeah.
I was like, I didn't know that was a child. I was like, what is that?
That's my now she's all embarrassed and she just ran upstairs.
No, don't be embarrassed. It just scared me. I was like, why is there a head there?
If you were pressing the button, she walked into the house, and so.
Oh, okay. Well, anyways, we're gonna go over the the motions to quash involving Taylor Swift, and then the ones from Stephanie Jones involving Edgeworth Security. We'll get into the Taylor Swift stuff first, because obviously there's been some accusations that came out today that were pretty much blowing up my phone. My phone was burning a hole in my hand this afternoon. I was like, oh God, like Jesus. So it's just gotten so crazy. But you weren't really up to speed on this, I guess, until
No, I had like a little ER episode yesterday, and
yeah. Well, since I accidentally announced that to everyone, why don't you tell everyone that everything's okay?
Oh yes, everything's fine. My child, my 6-year-old, was screwing around on the chairs in her kindergarten class, and she face planted and hit her head pretty hard. And she went to the nurse's office, and then she was, crying and stuff, and it was a little more serious than just a regular fall. And we took her to the ER because she was acting drowsy. And when we got her there, I was actually on live. I found out about it when I was live on stream with Brad. But when they got there, she threw up a couple of times, and so they're thinking concussion, imaging.
Mm-hmm. Yeah.
By the end of the night, around midnight, she was like literally singing show tunes that she was working on for her kindergarten graduation. And so the doctor said, yeah, I think you guys are good.
Okay. Well, I'm glad she's good.
Yeah.
Bruce is in the chat, like, Lauren, what's going on? I scared him, I think, because I sent him a text earlier that said, Bruce, I did something I can't come back from, and I forgot to answer him back.
Is this no homo thing?
Yeah, stop it. Stop it. We're not talking about that right now. All right, anyways. We're gonna pull up that first document, Omar, if you would please. Please just pull it up. We're not gonna talk about that. I want to say that I've told you, like, when I think I've told you, at least, when we go over anything Taylor Swift related, I get responses on all forms of social media where these Taylor Swift fangirls, no matter how nice I am about Taylor Swift, or no matter how like neutral I am on Taylor Swift, they're just like so mad at me.
Ask me and they're like shit about Taylor Swift fangirls.
What's that?
They get mad at me. You could direct their anger to me. I don't mind.
Oh well, no, it's okay now, because so like before they were attacking me in all manner of words, like you're a fat bitch and blah blah blah. But the thing is, like, now that this has all come out, crickets. And I know it's not anything that I did because I'm still fat. So obviously they're believing what they're reading.
Yeah. Well, what are they so upset about? Like, what are they angry for? Like, what did you even say?
I don't know. I don't think they have any friends on Twitter, so they need to make enemies, I suppose.
Oh, yeah. Well, what are you gonna do? To each
keep being a fat bitch, I guess.
Yo, I am so effing sore, man. My whole body is sore trying to get ready for this thing.
What have you been doing?
I've been trying to. Well, I haven't been. When you released your picture on, what was it, Instagram?
That picture's from 2012.
Yeah, but still, it's like, I'm so effed, man. I'm like competing with a collegiate swimmer, like legit. Like before, it was just an idea. Now it's like, oh yeah, she isn't like a collegiate swimmer.
Listen,
and, I have swum 0 minutes since the last time I told you about. I figured out, wow, I'm really bad at swimming. All I've been doing is like weight training. I've been trying. My plan was, look, I don't think I could get that much better at swimming in a couple of weeks. So I was trying to lose some weight. I wanted to get down from 215 to 205. I figured if I did that, I would have a fighting chance. Not much, but something. I'm down. I'm down like 211.
Huh.
What do you do? It's not going well.
It sounds like it's going pretty well. I think that sounds like it's going well. So yeah. If you don't know what we're talking about in the chat here, Omar and I are going to do a charity thing when I go out to LA in a couple weeks, and we're going to swim in his mom's pool. We're going to race in his mom's pool. And then the other thing, you wanted to do arm wrestling. I said we had to arm wrestle with foam fingers.
Foam fingers?
Yeah. And then the third thing was like karaoke or something. So we'll have to set up a website or a GoFundMe or something so we can get the funds for whoever, wherever the charity money is going to go. So, but yeah. Anyways, you want to pull up that first document so we can go over it?
Is it this Monat one? Well, let me just here.
Yeah, go ahead.
Share my screen. I have so many tabs open. You sent me so much stuff.
Yeah, in order.
Well, hopefully it stayed in order. I tried my best to open it in order. How's this?
I'm sure I can figure it out if you can.
First thing?
What is it?
No. This is not the first thing.
You know what, sir? Why don't I? You know, I can pull it up. Hang on, because you're doing some weirdo shit over there.
I mean,
not that that's unusual. Just you know, it's not what we're looking for at the moment. Call me later, though.
Well. Oh, all right. What a day, man.
Yeah, hang on. I'm gonna share mine.
I should unshare mine, I suppose.
Yeah, you're good. I think. It popped off.
All right, cool.
Let me zoom in a little bit. Okay, so did you actually look over this?
No, I've looked at nothing. I was going. I had about 30 minutes to do it, and I had to put my girls to bed, and time just ran out.
Yeah. So this is the motion to quash, and it's filed by Venable LLP, which is the firm that represents Taylor Swift. Yeah. And before we knew anything that came out today, it's kind of like, well, why did they send a subpoena to the law firm? So we didn't know. So they put out this motion to quash. And let me see what they were asking for again.
Oh, Rule 45D1 requires that a party issuing a subpoena must take reasonable steps to avoid imposing undue burdens. Subpoena seeks documents irrelevant to any claim or defense in the lawsuits.
Yeah.
Additionally, it exclusively requests the production of documents in the possession of parties to the lawsuit and or their counsel, namely documents involving alleged communications between 1, Venable, and 2, Blake Lively and Ryan Reynolds and their legal counsel. The law is clear. The proper way for consolidated plaintiffs to get these materials would be to go directly to the parties in the lawsuit, yet inexplicably, the consolidated plaintiffs nonetheless seek documents from a non-party law firm. The subpoena is an end run around the proper discovery process, does not seek any information that is relevant. Is there a response to this?
Yes.
They requested oral arguments?
No.
All right.
Well, it's actually, no, it's not a response to them. It's a response to Blake Lively, because Blake Lively and Ryan Reynolds then filed a motion to intervene and quash this subpoena because it was filed in the DC courts.
Okay.
And then they wrote a letter to Judge Lyman in New York and said, I guess do you have to do that? You notify them about what's going on there?
Have to do what?
So like they wrote a letter to the New York court saying, we've, made a motion to quash the subpoena to intervene in this other.
Yeah, you got to give notice. You got to give notice, and they got to
meet.
Yeah.
So it's not that they responded to this. They responded to the letter about Ryan and Blake's motion to intervene and quash with that information about Taylor Swift. So let me. Do you kind of get what's going on here?
Yeah, they're seeking documents that they think they should be able to get some other way.
Okay. And then they were asking for all this stuff from the law firm. Let's see if I can find exactly what they were looking for. Okay. I mean, a lot of this is just case background. Yeah. So they're looking for all communications between the firm, including without limitation Baldridge, who is Taylor Swift's personal attorney.
Yeah.
And the Lively parties, including without limitation their counsel.
Why are they asking for this non-party law firm these documents when they should be asking the parties? Is there?
Yeah. Mm-hmm. And then they mentioned in here somewhere that I think it was the end of page 8. No, I can't find it.
But this happens all the time. Just a little context. I subpoena non-parties for documents all the time.
Yeah.
And the reason for it is because if I'm requesting bank documents and I don't think that the other party is being forthcoming, I'm not just going to trust they're going to give me undoctored documents.
Okay.
And so I will subpoena bank records and ask that they be sent directly to the judge in a sealed envelope and to me directly. And so that way we have no risk of having altered documents. So,
so that's not like a weird request.
No, it's not. Okay. But they have an issue with it. So.
Okay. So this is the motion to intervene and quash that was filed by Ryan and Blake. Do you have that pulled up on your screen?
Reading it on your screen because it's way easier to find with my
No problem.
dozen tabs that I have open right now.
Okay, so I guess we could start right here. Lively parties have a substantial interest in the subject of this action, and the court's disposition may impair or impede the lively party's ability to protect their interest. Lively parties seek to intervene to challenge a subpoena that requests documents to the extent relevant at all that may contain the lively party's confidential information and their counsel's work product. The court should quash the subpoena or otherwise enter a protective order.
They're already in a protective order for this stuff, I feel like. Didn't we address this? Like, the only hearing that we've had in this case spoke specifically about confidential documents and what we were going to do, and there's going to be an extra hearing, which I guess is what we're doing.
They haven't said anything, obviously, but I'm sure that's what's coming.
Well, the attorney's eyes only protections for confidential communications, which is pretty standard. Like, I don't know. I feel like a lot of these protections that they're asking for are already in place. Am I wrong? Or am I misremembering?
Of course, that's what I thought, but I have to ask you because then, like, well, then maybe I'm just not getting some legal speak or something. But to me, it's kind of like, what are you talking about?
Yeah. Well, they're upset because this isn't an attorney's eyes only type of request. They're seeking arguably privileged documents, and they're trying to get it from a law firm, not like a governmental institution that regularly is in the practice of being the custodian of records and, keeping things above board. And they don't like it. So I guess technically it would fall outside of that spectrum. So sure, they're going to have oral arguments. It looks like they requested them and hash it out. But no, this is not all that exciting, I guess, would be.
No, I mean, all that stuff was what came out today. So give me 1 second here. I don't think there's really anything else here to see. It's not anything too crazy. I mean, there's a memorandum, but I don't really know that there's, like I said, anything to see here that's going to be super, super important.
Do they make an argument that they're requesting like vital records that are of utmost relevance to the causes of hand or something like that?
I mean, I don't really remember, to be honest with you.
God damn it, Lauren.
Sorry, this was yesterday and it feels like 3 years ago. So I can't even tell you. Like, all right, let's see.
We're supposed to be talking about Taylor Swift bull stuff.
Well, that is the next thing that's going to come up. All right.
You know what happened in my brain right now? I was going to censor myself. And then I was like, oh yeah, I'm at Lauren's channel.
Yeah, you don't do that here. All right. Okay. So they're just talking about the Wayfair parties and all that. Miss Lively initiated the Lively action to seek accountability for sexual harassment and a retaliation campaign designed to bury her. Yeah, we know. Okay. None of that is important to me right now. There's the request for production.
Yeah.
Let's see. Okay. They refuse to answer either question. Oh, that's right. Okay. Hold on. I'll go back up here. So I want to see why this is. So like Blake and Ryan had written to Wayfair Parties counsel about this, and they were like, no, we're working with the other law firm. We're not going to answer those questions.
Yeah.
So why is that?
A letter to Judge Lyman, right?
They did. They did. I think it was, I can't remember if it was this morning or if it was yesterday that they sent
their reason is straight up witness tampering, evidence spoliation, exactly what I just said. It was, they don't want to risk getting bad evidence because they don't trust them, essentially. They talked about Blake Lively allegedly requesting Taylor Swift to delete messages. We're supposed to be talking about that.
Yeah, it's coming up. Hang on. Let me pull it up. I don't think I need to pull up the letter about the motion to quash because that's you already know what it's going to say.
Yes.
Okay. Let's see. Nope, this is not what I want. Okay. You want to? So we'll just read the whole thing because it's not very long. You want to read it for me?
Yes, ma'am. I'll do whatever you ask me to do.
Don't say that.
Right. It's coming out of my mouth.
Ew.
No, Jesus
Just
Christ.
read the paper. God.
No homo.
Fuck you, man. Fuck you. Just read the paper. I hate you.
All right. We write in response to the letter to the.
I have to mute myself for a second.
We write in response to the letter. You're totally not muted. Um, plaintiff, consolidated defendant Blake Lively, and the parties, man. The Wayfarer parties anticipate that Venable's motion to quash will be mooted in short order as their counsel and Venable are conferring in good faith. However, the Lively defendant's insistence that the subpoena seeks irrelevant information is wrong. The subpoena aims to obtain discovery relating to witness tampering, evidence spoliation. Specifically, the Wayfarer parties' counsel are informed and believe, based on information from a source who is highly likely to have reliable information, that 1, Miss Lively requested that Taylor Swift delete text messages. 2, Michael Gottlieb of Wilkie Farr, counsel of the Lively defendants, contacted a Venable attorney who represents Miss Swift and demanded that Miss Swift release a statement of support for Miss Lively, intimating that if Miss Swift refused to do so, private text messages of a personal nature in Miss Lively's possession would be released. What a bunch of cunts.
Oh, hey, it's my line.
Oh, sorry.
Dude.
Wow.
Yeah. So
That's
we're not I don't think we're quite done there yet. Where do we get to?
No, I have to compose myself.
No, I get it. I get it.
The Wayfarer parties' counsel are further informed and believe that a representative of Miss Swift addressed these inappropriate and apparently extortionate threats in at least one written communication transmitted to Mr. Gottlieb. It is those communications that the Wayfarer parties seek to obtain by way of subpoena, so they would evidence an attempt to intimidate and coerce a percipient witness in this litigation. Holy shit.
Yeah.
As stated, the Wayfarer parties' counsel are in active discussion with Venable to determine how to proceed. Should those discussions prove unfruitful, the Wayfarer parties will either oppose the motion to quash or withdraw the current subpoena, as in there's nothing relevant, in favor of an amended subpoena seeking only the communications in question. Mm-hmm. I see why they wanted to quash it.
Yeah. Well, I mean, we'll get to the response to this, or the motion to strike next, but I just want to ask some questions about this, because people were saying some things like, and you know, there's always some theories that are always going around that I don't necessarily think that there's a lot of merit to them, but okay, so a lot of people in my comments were saying, like, what if they're baiting him? Basically, they're like, what if they set him up? I was like, I don't think that is what's going on here.
Yeah, no, I mean, if they're saying this in a letter to Judge Lyman,
right?
Here's what I know in civil court, man. Civil judges are sensitive. They're really sensitive. Just this morning, I was arguing a motion in civil court, and the judge took exception to a word that I used, the word being misleading. He's basically asked me, are you insinuating that this court misled purposely the docket, any of these parties in the case, to do whatever X, Y, and Z? Like, Your Honor, I think if you replace that word with confusing, that would be more apt in these circumstances. I'm not insinuating the court intentionally did anything. I'm just saying that my client was confused and deserves some mercy from the court. But it was just, you know, they get really finicky with words. And so if you're going to write a letter, especially to a judge like Judge Lyman, and insinuate these things on information and belief, you got some cold hard facts that you're relying on, and you know you're going to find something, and you're letting Judge Lyman know, hey, maybe there's something else behind this motion to quash. Mm-hmm. It's not just whatever stupid law that they quoted.
Yeah. Well, I mean, of course, you got people on the other side of the ball here who are saying, like, this was just they're just posturing or doing stuff like this. So they're just trying to make headlines and stuff like that, or they're trying to change the narrative to be Blake versus Taylor instead of Blake versus Justin. Like, I don't really think that you would risk it all like this to do that, but maybe I don't know. So,
well, you gotta first of all, Friedman and the Wayfarer parties, the way that they've litigated so far, ever since that hearing and that admonition from Judge Lyman, has been very, well, the opposite of David Gingras, put it that way.
Okay.
I mean, they've
Cool.
kept everything under
All
wrap.
right. Yeah.
They've not really had much to say about a lot of the stupid shit that was being thrown at them in these motions. They had virtually gone silent on a lot of these issues, and they were just getting pelleted with these 12v6 motions and all these other stuff, motions to quash, motions to compel. We're not going to extend deadlines. And they've been very selective in the things that they would respond to. Friedman, when there was the explosive stuff that would come out, would respond, but he would respond in like making a statement publicly. That's been his style throughout. He knows how to control PR. This is not a PR move. If Friedman wanted to make a PR move, he'd make one.
Right.
He wrote this letter to Judge Lyman and say, hey, Judge, where do you get a load of this? Because I think that they might have tried to shake down a witness. And I don't know all the details, but I'm going to get to the bottom of it. And the thing I'm going to use to get to the bottom of it is this subpoena. That's why they want to quash it. And I'm just letting you know it's relevant for this very specific reason.
Yeah.
I'm supposed to have a meet and confer. If I find out that it's not a thing, then I'll quash it myself.
So I want to speak to like some people who said, so my point when I read this was like, yes, this makes sense because Taylor Swift is a person who's always been very outspoken when other like female celebrities have been victims of sexual harassment, sexual assault, that kind of thing. And then all of a sudden the best friend whose children she's supposedly godmother to goes through this horrible thing and all this shit blows up in the New York Times. She's silent. And people are saying, well, maybe because I would have said the same thing, right? At some point that it's best if you're involved in a lawsuit or you're named in a lawsuit to just shut up.
Yes.
But that's not, I don't think that's what's happening here because she was never named at any point in Blake Lively's lawsuit. It was in Justin Baldoni's. And that New York Times article that blew this all up, that all came out well before he filed his suit. It was at least several days, and she didn't say anything, but, you know, Brandon Sklinner did, America Ferrera did, the other people who starred alongside Blake Lively and Sister to the Traveling Pants, or whatever. So, like, she had the opportunity to say something if she wanted to without the fear of, like, being named in a lawsuit. I think that she was genuinely surprised by it, and that she, you know, didn't say anything because she felt like something was off.
Well, I'll tell you
or maybe it's not a good idea for her image. I don't know.
Taylor Swift is a lot different kind of superstar than Blake Lively. Mm-hmm. Even I know who Taylor Swift is. And so when she speaks, like there's ramifications to that. It was not in her best interest to go out there making statements. I would imagine that she was trying to keep this all under wraps. I'd imagine that she's really upset that she's even in the middle of all of this. Mm-hmm. But yeah, I don't think that Taylor is going to come out and say didn't she want to quash the request to depose her? Did I miss that? I want to say I saw that yesterday. Is that not a thing?
Quash a request to depose Taylor?
Yeah, there was a request to depose her.
There was some confusion there in the beginning, but the actual thing that was being moved to quash was this request for production.
Not the okay.
So they have not moved to quash the subpoena against Taylor Swift herself.
Okay.
So just these, and I wondered that was why, because they were asking for, I felt like kind of a lot of stuff that they needed to narrow down, maybe, you know, as far as the law firm goes, and maybe that's why they didn't want to comply with that, or, you know, I'm not sure, but it sounds like they're cooperating now, or they're trying to cooperate or like work it out.
Yeah, well, number one, you don't really ever want to have to comply with subpoena if you're at risk of giving out confidential stuff and you're a law firm. Mm-hmm. Right. And so, yeah, they're talking about it. And it sounds like Friedman is really just trying to look, I don't give a shit about anything but this specific issue. Mm-hmm. Did Miss Lively request that Taylor Swift delete messages? Did Michael Gottlieb, counselor for the Lively defendants, contact a venerable attorney who represents Miss Swift and demand that Miss Swift release a statement of support for Miss Lively? Because that's bullshit. That's called witness intimidation. Not only is that, you know, actionable in civil court, that's a crime. Mm-hmm. Excuse me. If Miss Swift refused to do so, they were going to send private text messages of a personal nature in Miss Lively's possession that would be released. What could that even be? like a.
I hope you weren't expecting me to know the answer to that question.
I mean, it sounds like they got like some kind of like a Britney Spears type of paparazzi snafu, circa 2006 or something.
I don't know. I'm sure someone in chat could probably give us a better idea.
I mean, all I know is Taylor Swift has a very specific image, and I imagine she's really buttoned up, and it probably wouldn't take a whole lot for her to really not want something to get out there, even if it was like innocent or stupid or not that big of a deal.
Yeah, see, I don't have that problem.
Well, because you just post all of your snafus 11.5 minutes.
I post my embarrassing moments. I hang out with you in public. It's all pretty ill-advised, but
well.
Okay. So before we move on to the motion of strike, I want to read these really quick. Ness, thank you for the 333. Thank you, Lauren, for hosting this for us. No problem. It is late at night, but I'm here anyways. April sent this one for you, Omar.
Do you think Venable okayed Brian's letter? I don't think Brian needs anybody's okay. Miss Love. But yeah, I think he did. Honestly, I think he did. They probably talked about that, what they were going to say to the judge, and just letting the judge know, hey, we're working this out. This is what's going on.
Yeah.
Things are moving. Once again, this is a wayward attempt to try to scurry the evidence, but we have a plan. Yeah. If I find out what I think is going on is actually not a thing, then we will withdraw the subpoena and tailor it to something more relevant. But we need to have these discussions.
Yeah. We got 3 more. Hang on. And Maria, thank you for the $5 super sticker. Appreciate you. Let's see. KP. Omar is still covering this, but 2 lawyers and others disappeared. Do you think Blake and Ryan are trying to buy people, and can you be bought?
Yes.
First,
I can be bought.
No, you are ridiculous. Baby, you can buy him, but I am priceless. Okay? So that is not going to happen. But the 2 lawyers, they're covering some other cases right now. They said they would get back to it when something else came up that was huge, like maybe a motion to dismiss has been ruled on or something like that. So they just want to focus on other things. And to be honest, I can tell you from this side of the ball, maybe not Omar probably doesn't get as much of this because he's like a nice, likable dude with a nice face and a nice voice. And, people like that. But I'm a little crass and weird. So when you're getting this kind of like criticism day after day, and especially when people kind of harp on you and you get dogpiled over one thing, it gets pretty stressful. It gets pretty hard because like you want to explain yourself, but the more you try to explain yourself, and I know that they had a dispute with some viewers, the more you try to explain yourself, the harder it is to kind of get out of that hole. So I feel like it was probably healthy for them to just step back from that. I don't think that it's a matter of somebody being bought or anything like that. I think it just got really stressful and honestly understandable. Like I might say something at some point. I will say something at some point that people don't like. And it gets very stressful. I know that it feels honestly terrible. And when you're trying to run a business like a law firm, it's probably like you can't do all that. You can't handle all that. So
I'll tell you what, just to some advice for you two and for them. When I first started my YouTube channel, my little stupid channel, I took the criticisms really hard. I wasn't used to being criticized like that. I'm used to walking into court and like everybody marvels at everything that I say. And everything is wonderful. And like everybody thinks I'm an incredible lawyer or whatever. And all of a sudden I was like, hey, you didn't spell the whatever person's name right. Why don't you check on your facts? And like every little stupid thing. I mean, you could get really caught up in that. And then people that like get invested in some of these cases. And I was covering some of these true crime cases that people have been following for years. And I'm coming in, I get one little thing wrong. And then it's like, I'm never watching your channel ever again. You've lost all credibility with me.
You saw my comments, man.
And so, you learn, I learn, I don't give a shit, man. Look, I'm a lawyer. I run a law firm. I do a YouTube channel. I don't do this full time. I do it when I have time to do stuff. I do it when I have things to say. The danger of only covering the Lively case is that you pigeonhole yourself and lose the opportunity to cover other cases that might also draw additional people to your channel. And so for them, yeah, it was great. They got the Lively audience, but I think they probably collected as many subscribers as they're going to get from that because the people that are invested in it they're still going to be there. But there's the Diddy case going on. There's the Karen Reed case going on right now. There's all kinds of other things. The Trump thing, when I was arguing back and forth with Brad yesterday, there's so many different things to talk about. And so, no, I sincerely doubt that anybody contacted them and said, how dare you talk about this case? Here's $1 million to shut the fuck up about it. If somebody gave me $1 million, like, all right, I don't need to say anything.
Jesus Christ, dude. Just tell everyone, why don't you?
I'm just naming my price.
I can offer you like $3 and half of a cheeseburger that I didn't finish.
Well, I don't know what I would do with that.
Not to stop talking about the case, just to shut the fuck up generally.
Oh, well, I mean, well, hell, I'll do that for free. That's my general dip.
God damn it. There can't be two of us. All right. Let's see. Redondo Beach, thank you for being a member for 3 months. Blake is a see you next Tuesday. I cannot argue. Well, you said it. I cannot argue with that. And thank you for the $2. The more crass, the better. Well, I can help you in that department. So thanks, guys. Let's see. We'll pull up this motion to strike, which is the latest thing that came out. So they're talking about Brian Friedman and what he wrote in this letter, and I'm going to ask you to read again because
I got you, Lauren.
Because I don't want to. I'm going to be honest. Yeah.
Hey, I feel that.
Okay.
Okay. So, this is the one that I opened up originally. On behalf of our client Blake Lively, we respectfully move to strike the letter signed by Mr. Brian Friedman and filed earlier today. Of course, they would. When you ask, okay, here's a tip off. Whenever you piss off the other side, something awful, move to strike. Your Honor, what were you saying? I want to move to strike his last sentence. It's argument, counsel. Still, that's kind of like what's going on right here.
Okay.
That was bullshit. They are insinuating some stupid things that they have no business saying. I imagine that's what this is going to say. Anyway, so on behalf of our client, we respectfully move to strike the letter signed by Mr. Brian Friedman and filed earlier today. That letter, which was not filed with any evidentiary support of any kind, much less anything under oath, falsely accuses Miss Lively and her counsel of engaging in witness tampering and evidence spoliation based on an undisclosed anonymous source. Miss Lively requests that the court strike the Friedman letter pursuant to its inherent power to control and to strike material from its docket that is abusive or otherwise improper under the circumstances. And there's case law on that. It should be unnecessary to respond to anonymously sourced, baseless allegations recklessly leveled without any supporting evidence. It is worth stating for the record, however, that each of the allegations in the Friedman letter is unequivocally and demonstrably false. As a legal matter, the Friedman letter is improper. It doesn't seek any form of relief, is irrelevant to any motion and currently pending before the court, serves no legitimate purpose, is not useful to the court in any respect. Miss Lively filed it, damn it.
My bad, bro.
Just messed up my flow.
Sorry, I forgot I got to keep it down to your speed, eh?
Miss Lively filed a letter to which the Friedman letter purports to respond as a courtesy to inform the court about motion to quash proceedings that Venable commenced. I can't read way up there.
Oh, okay. So, okay. You're being picky now. You're doing that on purpose.
No, we're good. You're good. You're good.
Bitter. I'm going to make fun of your frog kick a lot now.
Oh, Jesus Christ.
Yeah, Jesus Christ.
Made fun of. I'm certain of that.
Just read the page, man.
You keep on. All right.
I moved it for you again. I'm trying to be helpful. I'm a bad assistant. I'm sorry.
Filed a letter to which the Friedman letter purports to respond as a courtesy to inform the court about motion to quash proceedings that Venable commenced in another federal court and to preserve her own right to object to a third-party subpoena. But she did not ask the court to take any action, and her letter did not merit any or warrant any response from Mr. Friedman, let alone one that purports to manufacture a conspiracy theory in order to obtain communications from opposing counsel via a third party. If I was Friedman, was like, well, then should I just bring a motion for sanctions and dismissal based on your attempts to witness tamper, based on the information and belief that I've received from my anonymous source that will be disclosed at an opportune time after discovery's been complete? How do you want to play this one? Because I could do this all day. Letter to the judge, that's short and sweet, that insinuates what I'm looking at with the promise to recant when I find out it's not a thing, or should I just blow the lid on it right now? What do you want to do? Ball is in your court. Anyway, the apparent intent of the Friedman letter is to launder scandal. It's really rich of them to use that word, to launder, when
Yeah, I
they
know
are
what you
guilty
mean.
of the evidence laundering, right?
I said the same thing earlier.
Yeah, is to launder scandalous and defamatory allegations about Miss Lively and opposing counsel into the press by abusing the court's docket and avoiding the order requiring attorneys, in this case, comply with Rule 3.6 of the New York Rules of Professional Stuff. Within minutes of the Friedman letter appearing on the court's docket at 1:50 p.m., media outlets began publishing stories concerning the Friedman letter. Your Honor.
Hold on. So wait, hold on. This
Okay.
this thing that they're talking about here, they actually the Daily Mail, who they're citing in the footnote, the media outlet who supposedly did this at 1:55,
Yeah.
right after it came out, as if I am not faster than them, FYI. Suck it. Anyways, the media outlet Daily Mail, who had the 40 plus paragraphs, there was actually an existing article that was just adding updates.
I mean, even
so they added like a one sentence or something to, and they were like, it only took you 5 minutes to type a sentence, and you're a journalist.
Honestly,
oh my god, this is sus.
They're being a bit much. They're being really sensitive about this whole thing. Look, if Friedman wanted to drop a PR statement, he would have done that. He tried to do it respectfully as a letter to the judge. He can't control the media getting a hold of the docket and doing what they're going to do with it. We've already addressed this. And all Judge Lineman said was, look, why don't we just be careful with the statements that you're making in public that are going to become inevitably the subject of media outlets, scandalous news stories, whatever. I feel like with what he had, with what he brought up, he was pretty respectful. And then he even said, look, Your Honor, I don't even know if this is legitimately a thing, but I have to follow up on it because failure to follow up on witness tampering could cost my client the case. I mean, and matter of fact, this specific issue very, very well may end up being dispositive of this entire thing. And so, look, if I find out it's not a thing, I will limit the subpoena or issue a different one. And they're bent on, they're triggered. Let's just say that.
Well, yeah, if you don't want this kind of press, then maybe don't extort people to cover up your extortion. So, that's not working for me. But I know you're probably going to say that extortion claim is not very strong on the Baldoni side.
Who? If they're extorting Taylor Swift by
letting
out her
yes.
or something?
So yeah, I don't know. I feel like I'm looking at this and I can only say from like a random bystander standpoint, which is obviously why we wanted to hear from you. But I felt like this was about as smart as an idea that fell out of a pine cone.
Which idea? What are we talking about anymore?
Just the whole extortion thing. Like, I'm gonna get her to delete her text messages and all that.
Extorting Taylor Swift. I mean, look, I think they somehow. Here's what I think. I think that being around lesser stars that they could control and extort and manipulate and make them do what they want to do has given them a false idea of their ability to do that to other people, such as Taylor Swift and Justin Baldoni. And they're trying to do it with these bigger folks that have the wherewithal to fight back. And now that we're in the middle of all this, look, it's incredibly stupid. Agreed. But we didn't even know. I don't know the timing of any of this. They literally tried to launder evidence. They literally the sham lawsuit thing, right? The sham subpoena, all of those things. Now it's all coming to light. This case is getting crazier and crazier, and they started off on a course, and the more that they've been down this course, the more that is coming to light, the more that is being exposed. They don't like it, and they're fighting back. I said a couple of days ago that I felt like the Lively parties are litigating this case like they're losing. And there's only so much you can do. Look, I mean, I learned really early on in my career, when you're winning the case, you shut the fuck up.
All right, fair enough.
When the other side is making a mistake, you let them. And the telltale sign is, look, it's always the case that when you hear a motion being argued in court, the side that the judge wants to hear the most from is the losing side. So if you want to know who feels like they're winning at the very least, just look to who's making the most noise. And right now, it's the lively parties because of all of this scandalous conduct that is, maybe it's, hey, like Friedman said, maybe it's bullshit. I don't know. But should I put it past them? They literally laundered evidence. What do you want from me? I'm playing the opponent that I know, not the one that I wish they would be.
Orange is the new Blake. Oh God, I think I saw that. That's right.
Oh, should I finish reading this thing?
Yeah.
Within minutes of the thing, 155, threatened exposed. So during a hearing on February 3rd, this court explained to the parties, it's funny they mentioned that, wasn't I just talking about this, that it would intervene if it turns out that this ends up being litigated in the press in a way that would prejudice the opportunity of the parties to a fair trial. You could scroll.
Oh, thank you, Your Majesty. I will. Is this far enough, sir?
I mean, yeah, that's good.
Okay, cool.
No, this is actually really important. This is really honestly telling. I got to read this again. This court explained to the parties that it would intervene if it turns out that this ends up being litigated in the press in a way that would prejudice the opportunity of the parties to a fair trial. The court should promptly strike the Friedman letter from the docket to avoid exactly the result it presaged. I love that word. At the initial hearing, whether to grant or deny a motion is vested in the trial court's sound discretion. Courts have the inherent power to control their docket and strike material that is abusive or otherwise improper under the circumstances. Yeah, but isn't it just going to be like he's going to request, give me an offer of proof that this is a real thing, and you can just conjure this into thin air? Like, Your Honor, I have a source. And for judge's eyes only, if you want me to disclose my source, I will. I'd rather it be honest so as to not compromise the discovery process. And that's a legitimate thing. Like I've literally done that before. It's like, Your Honor, I know that they're trying to discover this evidence. The problem with that is that I'm going to use this specific evidence to impeach the lies of my opponents. Mm-hmm. And so as an offer of proof, I'll tell you what it is in chambers, but I'm not going to give it to them. And I'm not going to tell them exactly what's in there because I'm trying to catch them in a lie. Mm-hmm. And the judge's like, yeah, well, that's fair. In other words, it's only going to be admissible if they lie. Yes. Cool. So no, we're not going to order them to disclose that. Okay. That's how it works. So fair trial, yes. This is a little bit different because I can't believe that Friedman, he hasn't shown himself to be this guy where he's just going to conjure some idea that has absolutely no basis in reality and use it to gain the upper hand in court. Everything that he's stated so far has been tied to truths. I can't imagine that this is any different. So I think if they have a discussion, it might go something like that, where Friedman's like, look, I got credible sources that I care not to disclose because I don't want to compromise the evidence coming in or the discovery or whatever. Maybe they go into chambers, maybe they take stuff off record. I don't know. But I'd imagine that the talk would be something like that. And then when the judge is satisfied with that offer of proof, he's not going to be quashing anything. That's my take.
I'm trying to think. So if you were in their situation, the ones who are moving to quash or whatever, moving to intervene and quash, you're saying if you're losing or you think you're losing, you just don't really do much. So what would you have done it right now at this point after he filed that letter?
I mean, look, I'm not saying that they're wrong to be doing this because, I mean, they might be successful. I'm just saying that when you're behind, you got to do something, man. You have to do something. Like the best example I could give is my client once. I was in LA. I was in this high-rise building. I was at this deposition. There was attorneys all over the table. My client was getting his ass kicked in this deposition. It was an SH accusation. It was this ridiculous SH case. Mm-hmm. And they were asking him about stuff that I didn't want him to answer. I don't even remember what it was. And they were asking him and going into areas that I didn't know was a thing because my client hadn't told me. And I just made this big old scene. As I object, I'm instructing my client not to answer. You know what? We need a bathroom break. Everybody needs a bathroom break. Let's take 15. And then I pulled my client aside. I had to do something. Otherwise, we were going into an area where I hadn't instructed him. And luckily, it was fine, you know, and ended up settling shortly thereafter. But that's what you do. Sometimes when shit like that happens, you have to do something. You can't stay silent. If you stay silent, you're just getting run over by the train. So I'm not even saying that they're wrong by filing this or making this request. It's smart because it is doing something. And to the extent that they're right, then hey, they're maybe calling Friedman's bluff or trying to do that. We'll see.
Mm-hmm. Okay.
But yeah, no qualms with them doing this.
All right. We get to the bottom of it.
The bottom of what?
The thing we're reading.
Oh, I'm trying. My light is blue.
I can't remember if you finished it or not. That's what I'm saying. I think we got to the end. Yeah.
My light is the wrong color. Now I've turned it off. Oh shit.
Well, I can tell you look purple.
Well,
I thought that was by design.
You know what? We're just going to take that one out of camera. Where was I at? She's citing law. Okay. Ms. Lively respectfully requests that the court exercise its inherent authority to control its own docket, strike the Friedman letter as unnecessary. It's really pointless to do that at this point. Look, it's already been broadcast on Laura Neidhigh's channel. And now
the Daily Mail got to it slightly after me.
Okay, fine. The Daily Mail then.
Yeah.
Sure, like dozens of other YouTube channels, you know, it's out there. People know about it. Whatever harm is already done, there's nothing you could do. And so, yeah, strike it if you want to, but we know about it already. You can't get back all the feathers once you drop them off the Empire State Building. Jesus, I can't talk.
What do you do in your free time?
Oh, I'm so boring in my free time.
I don't know. What you're describing to me right now sounds like you've seen some shit.
Well, if you take a sack full of feathers and you drop them off of a high-rise building, they're out. You're never going to recover all the feathers. They're gone. You know, it's like one of those. That
makes a little more sense than what was going on in my head when you said that the first time, but not quite a lot of sense.
Jesus.
You can just call me Lauren. That's fine.
Yes.
Anyways. There's this Stephanie Jones. What's that?
Did we finish this? I'm pretty sure.
Yeah, we did.
Yeah, they just want to. Oh, they reserve the right to move for Rule 11 sanctions. Get the fuck out of here.
What does that mean?
That means that they want to punish or ask the court to punish Friedman for bad behavior.
Okay. And
which was basically my threat when I was role playing as Friedman. It's like, would they rather me ask for sanctions against them, or motions to dismiss, or some other thing? I'm trying to do my due diligence here. What are they paying me for?
Oh, sorry. Somebody was showing the little feathers there for you.
Lauren is sexting.
Sexting? My hand? No. Whoa, man. I'm not sexter or anything. I don't do that anymore. Anyways. Let me get through some of these and then we'll go into that Stephanie Jones motion to quash with Edgeworth.
Sure.
Let's see. Amy Inez, I think I'm saying that right. I hope so. Thank you for the 5 alleged fake relationship with Travis Kelce. Heart you too. Well, thank you very much. I appreciate it. I don't know about that. What's that? Taylor Swift, I guess, is like I guess they're saying that it's alleged that Taylor Swift's relationship with Travis Kelce is fake. But I gotta tell you, I am not the arbiter of how straight relationships are supposed to work, so I could not tell you.
I'm just gonna go on a limb.
I cannot tell you.
All right. I just don't think that it's fake. That's a lot of hassle for a fake relationship.
Why? So I guess, I don't cover a lot of the ins and outs of these people's lives the way that I
just love football, and I'm so annoyed with Taylor Swift specifically because of the.
I did not expect that.
My brother literally came to my house to watch the Super Bowl and was like, I'm only here for Travis Kelce. He's like, you would be, you little.
Excuse me? What? Is he what? Oh my god!
Well, my brother's gay. He likes Travis Kelce.
No, I know who your brother is. We talked at your Christmas party on the thing.
Oh
what? Yeah. What? So why is he there for Travis Kelce instead of?
Because he doesn't follow football. He doesn't watch football. He's there to see the men in tights. Is basically what he was
Oh,
saying.
no, so that makes sense, yes. But he wanted specifically to look at Travis Kelce in tights, or he
Because he
wanted to
likes
see
Taylor
all the
Swift
dudes in
and
tights?
oh, you'll have to ask him, but he
I
mentioned
will, Omar.
Travis Kelce by name. It
Oh
was
my
the
God.
one football player that he knew about, so
Yeah, all right. Well, now that I'm trying to get that image out of my head, because guys in tights playing football might be your brother's dream image, but
hey,
not mine.
Chris
Okay.
is he's in the chat. He says, I was festive. I wore red. I was there to drop off Nala. That's his dog. I was watching his dog.
Oh, what's up, Chris?
But he did mention Travis Kelce by name. He's like, that's the only football player I know. And he like sat on the couch, all proud of himself, and he did a little
Travis
spin.
Kelce, not Patrick Mahomes.
No, my
Really?
brother don't like Mahomes. I don't even
Really?
think
Why?
my brother knows who Mahomes is.
Okay, he's the quarterback, Omar.
I know you know that, but my brother doesn't watch football. Does not.
Yeah,
Maybe
but
he
he's the
does.
one that throws the damn ball. How do you not know that one?
You'd have to ask him if he knows who Mahomes is.
I will again. All right. Okay, so that was the end of that. Wait, that's right. I'm supposed to read the rest of these. One sec. Okay, I actually wanted to ask you about this. Did you all know that the Judge Lyman's brother is a director in Hollywood? Thank you for the 5, Redondo Beach. So that, I guess he has a brother who works in Hollywood. I don't know if he's ever worked directly with Blake Lively and Ryan Reynolds, but people are very concerned that this is a conflict of interest. I tend to lean on the side of I'm not going to make those kinds of speculations, but I don't know.
Could you imagine being a judge and whenever you make friends with anybody in any industry, somebody immediately says that it's a conflict of interest?
Yeah, or if your dad comes to the courtroom, it's like,
I'll give you a specific example. I represented not Chris, one of my other brothers, in his divorce case. And then they claimed a conflict of interest. I'm like, Judge, I've met this lady once. I met her one time at a wedding. I've never talked to her. I don't know any special details about her that I wouldn't know from any of my other clients. And the judge is like, yeah, I agree. It's not inherently a conflict of interest just because you all are family or whatever. That was well, we don't have to get into details of that. I was representing him for a very specific reason.
You know what? You can tell me about it some other time.
I will.
Let's see. Who's the next one? This is for you, Omar, if you want to read this one.
Sure. Why haven't we seen the OG subpoena? Is it fake? What's the OG subpoena?
The Van Zandt subpoena.
Why? Yeah. Why haven't we? I know that it exists.
Well, apparently per one of the letters we're about to read, I think, or maybe it's not, but it's within the last few days, they've said that Blake Lively refuses to provide any information as to why they or how they got this information or whatever. And then Stephanie Jones is again refusing to produce that subpoena. So
I know for a fact that people have it.
Yeah, well.
And so I don't know, somebody doesn't want it out there. It should inevitably be produced.
Yeah. I mean, there's a couple of media outlets have it.
Yeah.
On hand. So yeah, all I know is they said there wasn't a court stamp, which tracks because there was no judge assigned, so there wouldn't have been. But
right. Also, That's not really a thing that you just when you subpoena or issue a subpoena as an attorney, as I do, there's no court stamp on that.
Well, everyone was making a big deal about a court stamp, so Omar, we're doing court stamps now.
I got a stamp for you.
Ew, Omar, your wife is right there.
Not like that, Jesus Christ.
Ew. Guy cooties. All right.
No, it was gonna say the stamp says no. I can't. I don't want to harp on your.
Yeah, tell me later. All right. Redondo Beach. Thank you for the 5 off topic, but you want some hot lawyer talk? Listen to Robert Alessi. Who's that? Oh, no. Omar left us. Where's your head, man? Where did you go?
Oh, I'm still here. My camera.
Well, yeah.
I should fix my camera.
I gotta say, you look better than you did before, but still a little fucked up.
Arguable. But you know what? I'm going to pause myself or mute myself while I fix my camera. Okay. I'll be right back.
All right. Off topic, but you want some hot lawyer talk? Listen to Robert Alessi. I don't know who that is. Man, y'all got to tell me. Thank you for that, though. Gemma, thank you for the 2. Is there any chance it ends with cuffs? We'll have to ask him when he gets back, because Omar is like a little cloud of pixels in space right now, I guess. I'll keep that started so we can pull it back up. We'll answer your question. Or by that, I mean, I'll watch him answer your question. because I don't fucking know. McHigh Life, thank you for the 5. Can we talk about Brittany Mahomes gossiping on a girls' trip that this is all based on Blake wanting Justin? Thank you. I appreciate that. Yeah, so I heard that rumor and I saw that, covered in a couple of channels. I guess I'm just kind of weird about blind items or like tips that come in like that. And it's like an anonymous source says this or that, because, if it's not related to the court stuff, I'm just like really hesitant to speculate on that stuff, I guess. I watch it just like everyone else does. So like I'll go watch my friend Elsie, or I'll go watch let's see who else. I watched Ashley a lot. Elsie, Ashley, and we did something together once. It was really fun. Who else? Of course, Leanne is on YouTube now. There's Omar, who occasionally graces us with his face, but not right now. And then there's Without a Crystal Ball is on. Cassidy O'Connell. So I've been watching it, whatever they decide to talk about on their channels. But sometimes I don't feel comfortable delving into that kind of stuff, because I'm just like, well, that not only is like involving Blake Lively or whatever, but it's also involving Brittany Mahomes, who I know nothing about and don't want to really speculate on. So totally. That's just me. Yeah, I know, Omar. I know what you're thinking.
By the way, my battery is dead, so there will be no more camera for the rest of the show.
Well, thank God for small miracles. Okay. So, yeah. Jim H, thank you for the $2. So I pulled this one back up. She says, is there any chance it ends with cuffs? And I think she's asking if there might be like criminal charges or something.
Well, witness tampering is a criminal offense. Yeah. So yeah, maybe.
If that's what happened, yeah.
If that's, I mean, I don't know. Yeah, there's a lot of stuff that is technically criminal in nature. Some of the Shamzam stuff, wiretapping.
Oh, we're gonna get into that now, actually. Hang on.
Yeah, there's a lot of criminal implications in this case. Let's just put it that way.
So there's just a few more things. Are you able to see the screen, or you just?
I can. You just.
I just can't see you. Okay,
which
so
is
that's
probably for the best.
No, that's actually a terrifying scenario for me. But
well,
okay. So Stephanie Jones moved to quash the third-party subpoena to Edgeworth security firm. So I'm not going to pull this up because I can just explain it, I guess. If you haven't even, you may have even seen this already. It's been several days now, but she doesn't want them getting the documents and communications from Edgeworth, the security firm that they used when they fired Jennifer Abel or terminated Jennifer Abel, and they got the stuff off her devices, and they had that one security guard who was allegedly like kind of pressuring her to stay in the room, if not outright keeping her in there. So then the response to that, we'll pull that up, is they're saying they want to invoke the crime fraud exception to these communications because Stephanie Jones says they're privileged. And they're saying, well, no, because of this exception. So can you explain that to us?
Sure. I'll give you, I will give you a similar example. So California is a two-party recording state. Right? If you illegally record somebody, meaning you record them without their consent or knowledge, that's technically a crime. That's under Penal Code Section 632.
I think that's the same. It's the same here.
Yeah, actually. But there is a limited exception to that. Like, for example, you're allowed to make a surreptitious recording if it's for the purpose of exposing domestic violence or some similar crime and showing it to the judge for that limited, very specific purpose. You can also introduce evidence of a surreptitious recording, arguably with the judge's permission, to impeach sworn testimony of one of the parties. So in other words, you have this secret recording and it was illegally obtained because they didn't know that you were recording. But he just said, well, we never made an agreement, but Your Honor, I have him on a recording where he told me that we agree on all these things. And then he says, well, I didn't know I was being recorded. Penal Code 632 is like, yeah, well, maybe so, but he just lied on the stand. So perjury, bitch. And then everybody's breaking the law.
So perjury, bitch, is how that. Okay, just checking. All right. Oh man,
it's kind of the equivalent. The same thing that's going on right here.
Okay. Let's see. I mean, you pretty much just explained it there. We haven't gone over her response yet, but that'll be like the last thing we go over. But let me close this real quick. Let's see. So I want to see exactly what they were saying at the bottom here. Let's see. Okay. On September 27th, Lively and her counsel, let's see, initiated a proceeding in New York State Court, Van Zandt Incorporated versus Doe's 1 through 10. A true copy of the complaint from the sham action is attached as Exhibit A. The sham action was a transparent ploy to manufacture a procedural vehicle by which Lively could subpoena JonesWorks for Miss Abel's communication without notifying any of the Wayfarer parties, including Miss Abel, all of whom lacked notice thereof and were deprived of any opportunity to object. The plaintiff, Van Zandt, is an inactive corporation affiliated with Lively and her husband, Ryan Reynolds, and unrelated to the film. The Van Zandt complaint is devoid of specific allegations against anyone, much less Miss Abel, relies exclusively on recitations of boilerplate legal jargon, and implausibly alleges that Van Zandt is unable to identify its own contractual counterparties. So that last part there about the counterparties.
Yeah.
I've heard some people justify this and say, like, no, this is just like a regular thing that lawyers can do. I disagree, obviously, because everyone else that I really listen to, except for these one or two people, will say, no, you can't just name John Doe's and not notify anyone of the subpoena and then not name anyone and then just kind of dip out. Yeah. So as far as the unable to identify its own contractual counterparties, why are you even able to file a lawsuit like that in the first place and try to enforce a subpoena in the first place?
Well, because when you file stuff, they're not going in front of a judge, they're going in front of the clerk.
Okay.
And as long as it's technically sufficient, then they're going to allow it, and then there's going to be this complaint and there's going to be this time frame where you're supposed to serve the other party, but there is no other parties. And so it just stays on the docket. It's not assigned to a judge likely, or maybe it is, but there's no hearing dates or anything. And when you issue the subpoena, you don't have to notify anybody, just like they said. You can technically do that. But the ridiculousness of it all, the brazenness of it all is essentially this. You and I make a contract. I am party A, you are party B. I would never make a contract with somebody unidentified that I didn't know. At some point, you have to ascertain who this other party is, or at least the entity that they represent, or the vehicle or the agent thereof of the party that is involved in the contract. But there's never a scenario that you're making a contract with an unidentifiable ghost. And so she's saying, we have contracted, I will give you $50,000 for this specific service. Great. What they're saying is, I had a contract. I was going to give them $50,000. I just don't know what I was getting or who I was getting it from. So it was frivolous. It was disingenuous. Mm-hmm. So such as to be fantastical, unbelievable. It was such an egregious disrespect of the courts, miscarriage of justice in the way that they filed it, and this backwards way of laundering evidence that it should be punishable, honestly, by sanctions.
Okay. Oh, Cassidy's here. Hey, Cassidy. Have you talked to Cassidy yet, Omar?
No, but I can't talk.
Use your words, man.
I would relish the opportunity to do so, is what I was trying to say.
All right. Yeah.
I rue the no, I don't rue. I relish. I relish the opportunity to do so.
Well, while you're trying to find your words, I can probably facilitate that afterwards. We'll figure that out sometime.
We'll figure it out.
Yeah, I think you guys would get along.
Yeah.
Okay, so we got through that. Let's see. I mean, this letter pretty much isn't going to say more than you've already told us, I don't think, but let me read through this just in case. In her amended complaint, Lively represents to this court that she obtained Miss Abel's communications through legal process, including a civil subpoena served on JonesWorks LLC. Mm-hmm. JonesWorks similarly represents that it received a subpoena for the phone's contents. Let's see. And then here's where they're like making a point to point out the wording here. So JonesWorks disclosed Ms. Abel's communications to Lively, and this is according to JonesWorks, in response to a court-ordered subpoena. And then they're saying it's unclear how the sham subpoena could be court-ordered. So does it matter? Like, how much does it matter that they used the wording court-ordered subpoena when they were referring to this? Because her attorneys have admitted they went on like Hot Mic with Billy Bush or something. They admitted this is where we got that information. This was the subpoena, but it's not a court-ordered subpoena. So does it really matter that much? How they worded that?
At worst, it's misleading.
Okay.
At best, it was just a mistake. Mistakes happen all the time. But yeah, it would be weird if you are an attorney with subpoena powers and you title a subpoena court ordered.
Yeah.
But it didn't have a stamp. And so, I mean, I don't know, maybe some paralegal screwed it up, but I hesitate to give them that benefit of the doubt because of the way that they've operated so far in this case.
Yeah. All right, let's see what else they got in here. Court ordered subpoena. I think, yeah, that's pretty much it on that letter. Let's get to the next one. Okay, so this was the latest one in this like series of letters. Hang on. And then since they filed this one, nothing has happened. So they ruled pretty quickly on that motion to compel because the ruling came out today for that. But
right.
Let's see. But it's kind of like I'm confused as to, and I guess maybe you could speak to this as well, because a lot of people are asking, how long is it supposed to take for rulings on this stuff to come back, and why does it seem like it's taking forever? Because I'm not saying I think because I, listen to a lot of different people who say give me a kind of different answers on how long it's supposed to take. I presume it could take a while, but lots of people are saying it feels like it's taking forever. Is that a problem? Is he just not doing his job? I'm just kind of like I don't know about all that, but.
I mean, I think a lot of the attorneys that you hear like commenting on how long it's supposed to take or how long they think it's going to take is all bullshit.
Okay.
It takes as long as it needs to take. How about that? These 12B6 motions, the judge is going to take his sweet ass time to make sure he gets it right. He's got a trial scheduled for February of next year before he starts deciphering whether or not these 12B6 are going to be granted, or he's going to ask them to amend certain things specifically. He's going to allow the discovery process to play out. He has his own methods. He'll take as long as he damn well pleases. How about that?
Mm-hmm.
But no, it's not. It is not uncommon for certain things to take longer than others, and the things that's taken a while is justified. You should get those right.
Mm-hmm.
But it also tells me that he's putting considerable thoughts into the arguments. I think that he thinks that there is some merit to the 12B6s that are pending.
I know he said something about in one of his rulings, something about the New York Times, how they had like a good case or something like that. He didn't use those words, but
yeah, but he's also insinuated in some of his other rulings in the discovery stuff. Like, you guys have been telling me that you wanted to or knew that you needed to amend this complaint for weeks now, so fucking amend it. I'm not going to extend your deadline. If you want to amend it, then you do that. And the deadline is the deadline, and so he's basically signaled to both parties that there is some merit to some of this stuff, and you guys know what it is, so fix it, work it out amongst yourselves.
All right, fair enough. I'm going to ask you for a favor.
Okay.
Can you read this while I go to the bathroom real quick?
Yes, I can.
All right, thank you, and have fun. Bye.
I'll
be right back.
All right. So this is reply in support of motion for protective order. Okay. So it's a letter to Judge Lyman. In their opposition of Jonesworks' motion to prevent the Wayfarer parties from using a third-party subpoena to Edgeworth Security Services, LLC, to invade Jonesworks' attorney-client privilege and work product, the Wayfarer parties engage in litigation by ambush. They assert an outlandish theory that they never raised during multiple conferrals and assert facts without evidentiary basis. The court should reject their baseless argument and grant Jonesworks' motions. As an initial matter, the Wayfarer parties fail to contest that the documents they seek from Edgeworth are Jonesworks' privileged documents. Indeed, by invoking the crime fraud exception, the Wayfarer parties have conceded the privilege. And they cite this case in Ray Richard Rowe, Inc. from 1999, because as detailed below, the Wayfarer parties' invocation of the crime fraud exception fails to meet any of the requirements for the exception, and they have not otherwise challenged Jonesworks' privilege. The court should uphold that privilege. The Wayfarer parties have fallen far short of asserting a proper, let alone viable, invocation of the crime fraud exception. A party seeking to invoke the crime fraud exception must demonstrate that there is probable cause that the client communication or attorney work product in question was itself in furtherance of the crime or fraud, and two, to believe that the particular communication with counsel or attorney work product was intended in some way to facilitate or to conceal the criminal activity. The showing that the exception applies must be made as to each communication. The Wayfarer parties have the burden to submit evidence establishing probable cause that the crime fraud exception applies. I don't have Lauren here to scroll the page any further. So I will read this footnote. The Second Circuit has not addressed whether the probable cause. Oh, there she goes. I shall resume. Even before the court can engage in a camera review of the documents at issue, and camera just basically means in chambers, the Wayfarer parties must present evidence sufficient to support a reasonable belief that in camera view or review may yield evidence that establishes the crime fraud exception's applicability. And they must provide the court with sufficient facts supported by evidence to specify the factual basis for the crime or fraud that the documents or communications are deemed to have furthered. Oh, I think we could do that. I mean, hell, I did that a few weeks ago. First, totally. First, the Wayfarer party fail to even attempt to connect any of their arguments to any particular privileged documents or documents. They don't even try to explain, for example, how a category of documents from May of 2024 that relate to defamation against Jones Works 3 months before Abel's termination could have been intended to facilitate an undefined purported scheme related to post-termination conduct and events. This failure alone is sufficient grounds to reject Wayfarer's argument. Scrolling down. Second, the Wayfarer parties present no evidence of their outrageous allegations against Jones Works. They present no evidence of their allegation that Jennifer Abel was falsely imprisoned by Edgeworth's security personnel. They present no evidence of their allegation that Abel was coerced by Jones Works' chief of staff and lawyer to return the phone Jones Works provided to her for her employment. They present no evidence that Jones Works accessed everything from her personal iCloud and email accounts, and they present no evidence of any of the specious criminal hacking allegations they level against Jones Works. Instead, the only documents they cite at all for their allegations is Abel's own amended counter complaint, which is equally unsubstantiated, unverified, unsupported. But a complaint is not evidence and cannot support the Wayfarer party's attempt to, hey, were any of these complaints verified? Or are these all unverified complaints? I'm going to take it that you don't remember. Neither do I.
Do you mean verified by what do you mean?
Well, there's like a verified complaint, like I signed this.
Oh, shit. Yeah, I don't remember. I'm sorry, man.
No, you're good. I'm just saying because verified complaints are evidence. Okay. You can use that to impeach. They present no evidence of any of the specious criminal hacking allegations they level against Jones Works at 2. Instead, the only documents they cite is allegations of amended counterclaim and stuff. Okay, so but a complaint is not evidence. I read all of that. They're citing case law. The allegations in the complaint cannot suffice to establish probable cause to believe that a fraud was perpetrated. Otherwise, through the mere allegation of fraud in a complaint, a party could use the crime fraud exception to wholly swallow the attorney-client privilege. Indeed, Jones Works has moved to dismiss Abel's amended counterclaims because the allegations are not only false, but would fail to support any legal theory she advances. The Wayfarer parties present no evidence of a crime, of fraud, or Jones Works' involvement in either. So their invocation of the crime fraud exception fails. I got to tell you, they're sort of right. I'm really curious about the retorts. Okay. In fact, the Wayfarer parties present only 2 documents other than their own prior pleadings in purported support of their argument: a complaint filed by a third party, not Edgeworth, in New York Supreme Court, and the notice of discontinuation of that litigation Neither of those documents offer any factual or evidentiary support for any of the Wayfarer party's wild claims. They do not relate to Abel's termination in August. They do not relate to Abel's return of her JonesWorks owned iPhone to the company at the time of that termination or alleged access thereafter. Even the Wayfarer party's effort to connect these two documents to JonesWorks is supported by nothing more than wild speculation and yet more bald repetitions of things the Wayfarer parties previously alleged. None of this approaches the showing necessary to support invocation of the crime fraud exception. They're citing case law. Scroll down.
Okay.
What is more, despite the Wayfarer party's bombastic allegations of a sham action, those allegations even taken on their face, fall short of establishing any cogent theory of a crime or fraud involving JonesWorks and Edgeworth that could support the exception. The cases the Wayfarer party site confirmed this. For example, in Michael Greco Productions, Inc., the court found, based on evidence, including altered contracts and the defendant's admission to having altered them, that the defendant presented an altered document to the court intentionally in order to defraud the court. Mm-hmm. The Wayfarer party's rhetoric aside, their bald allegations that JonesWorks colluded with Lively to issue a lawful subpoena in a case that Lively purportedly did not intend to fully litigate falls well short of a fraud corrupting the administration of justice that could sustain the exception. The Wayfarer party's lack of evidence is unsurprising, as the facts they assert are false. JonesWorks did not imprison Abel. It terminated her employment in a conference room. It did not coerce her. It provided her documents that she reviewed and signed. It did not threaten her. It requested that she return the iPhone that belonged to it, and she did. It did not hack her iCloud accounts or email accounts or even access those accounts or any personal information. It forensically extracted data from the storage of an iPhone it provided to its employees to use during her employment. If the Wayfarer parties had evidence supporting any of their inflammatory assertions, they would have presented it to this court. That they did not both confirms the non-existence of evidence and defeats their opposition. Scroll down.
Yeah. Oh, that's pretty much it. You're at the bottom here. Yeah.
Well, the timing of the opposition coming just 2 hours after JonesWorks' motion, its assertion of an argument not mentioned in over a month of conferrals and reference to a since abandoned claim, all demonstrate that Wayfarer's response was a pre-baked, media-targeted ambush, not a reasoned response to resolving a legal dispute. These tactics should not be indulged. And because the opposition fails even the most basic requirements of invoking the crime fraud exception, the court should reject it and grant JonesWorks' motion. They kind of got a point.
Can you dumb that down for me like a lot?
Yeah, look, they're alleging all of this criminal stuff, and there's not a modicum of probable cause. These are wild allegations, unsubstantiated by evidence. Yes, there was a lawsuit without a named defendant. Yes, there was a subpoena that was the basis of that lawsuit. Yes, we obtained information via subpoena, but nobody could say that that was illegal. Nobody could say that that was even that was technically illegal. Nobody could even argue. I mean, you could argue that it might have been unethical, but it was in the furtherance of causes of action that have led to different things, whatever. We got it legally is the point. There was no evidence laundering is what they're saying. And if they're upset at our methods, the way that we went about it, well, too damn bad, because it wasn't against the law what we did. And unless they have something better than that, then you don't have probable cause to raise the crime fraud exception. Okay. It wasn't fraud if it's legal. It's essentially what they're stating. What's the retorts? Now you got me into this shit.
There hasn't been anything at this point.
Well,
this was last. Yeah, this was last. It was a day or two ago. Yeah.
No, I mean, I guess that's the problem. Like, it wasn't technically illegal what they did. And all of those points are, look, when I brought up the potential crimes, I was talking about wiretapping, I was talking about illegally accessing some of Abel's personal stuff, iCloud accounts, whatever. I don't know if that's true or not. I don't know if there's evidence to support that they did those things or not, but they did own the phone. They performed a forensic analysis of a phone that was owned by an employee as, I guess, part of due diligence, you could argue.
Well, is it possible that they had someone analyze what the activity on Jennifer Abel's iCloud account and found out that the phone that JonesWorks had was accessing stuff on the iCloud account?
Wait,
after, you know what I'm talking about? So we're saying we don't have any evidence that they were, doing all this hacking her iCloud and all this stuff. Is it possible? Like, I'm wondering if it's possible that they had someone, since it is Jennifer Abel's iCloud account, it's not like they need a subpoena for any of that information. They could just have someone independently check Jennifer Abel's iCloud account and see that the device used by JonesWorks or that was attached to was accessing certain information on the iCloud. Like, that would be timestamped and able to
that would be
retrieve. So that would be enough. Yeah.
No, they broke. You can't access that personal. Look, there's if there is clear boundaries on that phone that lead to Abel's personal information, even if they extracted it accidentally, they can't go into it, But that's kind of the point. Look, I'm assuming that they're probably going to argue that, they did a full-on extraction and extracted her personal information and used it to form the basis of a future lawsuit.
Mm-hmm.
And they're trying to disguise it as, oh no, we were just doing our due diligence in the course of what we normally do for former employees. And then the question becomes, okay, well, is it your common practice every time there's a former employee that is issued a company cell phone that you do a forensically digital extraction of all the data on that phone? And if you don't, then why did you do it for Abel? And then the implication would be obvious, right?
Mm-hmm.
And so, it's not that they don't have any evidence. It's just that they're making the arguments that you're supposed to make. Name one thing that we did that was illegal.
I think, like Cassidy just pointed out, apparently they were still accessing this information until 4 months ago.
And if that's confirmed, then they do have.
And that would be confirmed by any analysis of her iCloud account. Like, they could tell what device and when that happened. So that would be enough. Yes.
That would be probable cause of a crime.
Okay.
And I stated it specific code in New York and in California and federally what that would entail. And if you have that data that shows an illegal contact by them, then sure, that's enough for probable cause.
Right.
Arguably, I'm sure they're going to argue against this. Oh no, it was accidental. Yeah, well, and then you get into further argument that would resemble some of the stuff that I just talked about.
All right. So that was the last thing we had the actual pages and stuff we had to go over. Hang on. We're heads. I'm going to see if anybody else has any questions. We'll go through the starred chats first. Hang on. Oh, this super chat is for you, Omar, but it's about me, so it's probably your favorite kind.
Oh, yeah. It's my whole assistant. She used to be my paralegal, Samantha Aparicio, with $2.
Oh, nice. Hey,
I'm obsessed with Lauren. Well, that's fucked up, Samantha. What am I, chopped liver? She would say,
I get it, man. No, I get it. Okay.
Yeah.
Thank you, Samantha, for the compliment. I'd be obsessed with me too if I was free of Omar and finally seeing normal people.
Samantha. Her she has a husband. Her husband's really into cigars.
Mm-hmm.
And we never having met each other bonded over cigars somehow.
That's cool, man.
Yeah.
You got two more here. Here's the next one.
Solid armor with 5 and a Superman avatar says, if this extortion tampering is found to be true, how would criminal actions be imparted on the offending parties? Would Justin get anything from it? No, they would just be prosecuted for the specific crimes that they're being brought up on. And it honestly would have no bearing on the civil case whatsoever, but for if they bring charges now during the civil case, they won't be protected via Fifth Amendment because they're in a civil case where they're not offered those protections. And Judge Lyman is not extending this further out until the completion of the criminal case. And so that would be one way, I guess, that it could affect it. But no, unless they're It wouldn't be a crime against Justin, though. It would really be crimes against Jennifer Abel. If anybody's going to get anything restitution-wise out of it, it would be her. So no to that question. If the DA over there wants, or the prosecutor over there wants to drop charges, they'll do it whenever they're good and ready. But it would be smart of them to do it now in the middle of a civil case, because now they don't have to worry about Fifth Amendment stuff. So there's that.
Okay, and here's the last one. One sec. There you go.
April Love, how you doing? It says, with the 5, says, would a jury be told not to consider the facts in the defamation case for the SH case as far as determining JB's guilt, innocence, or credibility? I got to read that twice. Would a jury be told not to consider the facts in the defamation case? I sincerely doubt it. Because those are almost competing causes of action.
Okay.
Like one side is claiming SH, the other one's claiming defamation. Those are competing causes of action. I can't imagine that the judge would hamstring either side just because of that. I hope that answers the question.
All right. Let's see. I got a couple more here. LK, thank you for being a YouTube member. I appreciate you. All right, let's see. I have this one here. Redondo Beach, thank you for the 2. Omar read my email, goodish news. What are you guys emailing about behind my back? Just curious.
Stuff.
That's what I thought.
But by the way, I did read your email, Redondo, and hey, good news is better than some of the other stuff.
Hey, I read my emails. Usually takes me about 3 to 5 months, but I do read them. Omar, this one's for you.
All right. What's up, Samantha? Omar, settle down. You are still loved. I need to figure out how to get on this podcast. Could be interesting. Well, God damn it, we could arrange that. Just text me.
I'd be happy to trade you guys out. That's fine.
I'll get Samantha on the lively case. She's I didn't know it, but she's invested in this case. And so hell yeah, you guys would love Samantha. Sweet. Where shall I submit an application? Yeah, just shoot me a text. We'll work something out.
You have to hand deliver it by 11. Better hustle.
Yes. Is it already that late? Jesus.
Well, for you it is. For me, it's about 2 a.m. We're getting close. Yeah. All right. So those were all the super chats, and I think that's all we had to go over tonight. I don't know if there's anything else that you wanted to discuss, really, because I feel like we haven't been together in a while. Last week. What happened last week, man?
We were
gonna stream, really busy,
and then we're like, nah. I think that's kind of how that went.
Yeah, there was at one point where I was just like, oh my god, I might have to sleep.
Yeah, and then I kept you gave me the bat signal, but I was streaming with Brad.
Oh no, dude, that was like 2 days ago.
Yeah, and I got your text here. Answer your freaking phone. You're like all caps, like Jesus.
I was in a state of crisis there because I had the Taylor Swift thing came out, the actual motion to quash by the firm, and I was like, well, I am obsessed with getting to everything first, because that's what I got going for me, is like, I might not know everything. I don't have the skill set of a lawyer, but I will be there first. Okay.
Yeah.
So,
you're the hardest working lady.
Yeah. So, but I had taken a melatonin and a half. So I pulled it up and I was like, oh, fuck.
Yeah.
So, I was just so sleepy. But then, I don't know if you saw, I went over to your chat and I was like yelling at you.
Oh, you
like,
were?
Omar. Yeah,
was
Omar. Hang up your stream, Omar.
Or was I yelling at Brad? It was either one. Was it one of the two?
Honestly, I don't know. I didn't get to hear it because I was doing that. So
yeah, well,
I was gonna put it on before I went to bed because I think you guys were still on by the time I finished. But then I remember that night, somebody had recently told me to watch this, and this is really random. This Korean game show on Netflix. And I was like, okay, so technically this person has never led me wrong, so I'm going to try it anyways. And so I turned it on, and I was like, maybe I should have just listened to Omar's politics. It made him have put me to sleep, faster. But I put it on, and then so I fall asleep listening to these people dubbing over Korean. And I had the most terrifying dreams where I didn't understand anything these people were saying when they were trying to burgle me.
Yikes.
Yeah, they're right. It was so bad.
Well, how did you respond? Like, what were you yelling at them?
Nothing, dude. I was frozen. I have that problem in my dreams a lot. It's like I know what I need to do, but I can't move. I'm like paralyzed. Have you ever had that?
Yeah, I used to have those dreams.
I have that one, and I have the one where I am suddenly like I'm in the cafeteria or something at my high school and I'm naked.
I get that one. You know what I get most common? I get like, holy shit, I'm back in law school and like the final is today and I just fucked off the whole semester and I don't know what we're being tested on and like I'm late to class and I can't get there and like trees are falling blocking my path and then I can't find the classroom and then I'm in this other one and I hate those dreams all the time. All the time.
So, April says, damn, Lauren, your dreams hate you. Yeah, they do. Yeah, they do. Oh man. I don't know. Sometimes they're good. Like usually the good ones are like somehow I have flying abilities. So, that's pretty cool. I guess I'll take a chance with sleep again tonight. We'll see how it goes.
Well, hopefully you get some good rest. The good REM.
It'll be rest.
You got to sleep more than 3 hours, Lauren. It's not healthy. It's not.
Well, only if I don't dream in Korean. Because holy shit, that was bad. Anyways,
dreams about.
Cat. So this is funny. Cassie says I dream my teeth are falling out. I don't know what happened or like what I discussed and with whom to make this happen. But you know how their phones, they're not supposed to be listening to us, right? But all of a sudden our targeted ads are like based on stuff we talk about.
Totally listening to us.
Okay, so my targeted ads on Instagram, like literally every other freaking post, they're all for people who are missing teeth.
I've heard about that with you.
Right. Yes, that's right. Oh, that's right. Because okay. So all I can see now when I'm getting ads is like people, and they don't just like tell you this is for people without teeth or people with bad teeth, right? They show you. So every other fucking post on Instagram is like bad oral hygiene. And I'm like, why are you doing this to me? What did I do? Who did I piss off to deserve this?
Hey, Christina Erickson says that ashwagandha is awesome too. And it is. You should, honestly, it's really good for you.
I had an ex-girlfriend who was really into that stuff.
Yeah.
I never ended up trying it, I don't think.
I mean, it's not going to hurt you. A gram or two a day. It might just put you in a better mood. Might allow you to think a little more clearly. It's a nootropic. And it's hard. It's a nootropic. It's good for you.
I'll think about it. What about an old tropic, maybe? Yeah.
An old tropic? Yeah.
Yeah.
No, don't. No. Don't do an old tropic. I saw an old timey 50s commercial advertising cigarettes, and they're like, "Smoke Camels. This is the cigarette that doctors prefer. If you smoke Camel cigarettes, then you will cure your smoker's cough."
Yeah.
And ridiculous stuff like that. Totally.
Did we just solve the world's problem with
We might have.
tobacco?
Michelle Moulton says that Omar is going to get them from being near you at the swimmers. What am I going to get?
I don't know. What do you think I have?
I don't know. Michelle said it. I'm going to get something from you at the race.
Michelle
Moulton.
No, I know who Michelle is. Yeah. I know who Michelle is. I'm saying, Michelle, what the fuck? I don't know what she's talking about, but unless she means targeted ads about bad teeth.
Yeah. You know what they used to do to cure women's depression back in the 20s?
No, I don't.
Well, you should research it. Just don't do it on your work computer.
Okay. Well, in my 20s, I used Zoloft, but that's fine.
Jesus, Lauren.
Yeah, I'll look it up, but not now because I'm afraid I know it's going to be of some nature that's just disturbing. So, unless it's a lobotomy, then I know what that is. Yeah,
not a lobotomy. It's just
I think that was the 50s, right? Was it the
misogyny?
50s? No,
lobotomies were. Yo, I read a book about lobotomies and like the backstory of the guy.
Were you preparing for your upcoming surgery when you were reading?
No, but he had a kid who died in this horrific camping accident, just floated right off of a waterfall. And it inspired him to create lobotomies. I don't have any more details on that. I read it a while ago. I'm just saying that guy's got a crazy backstory.
Wow, thanks. That was conclusory. Yeah.
Totally conclusory. About as conclusory as I get.
Oh, Cassidy says they went to special doctors who would cure their hysteria. Do I want to know how they were curing the hysteria? Because
you do. You totally do.
Ah, fuck. Fine.
It was
All right.
the
Hang
height
on.
of misogyny. Someone would argue.
All right. Hang on.
Oh, she's gonna look it up.
I'm not going to read it out loud. I need to know what you're talking about.
I'll read it out loud.
Okay. We said 1920s.
Well, the turn of the 20th century, say 1900s to like 1910s.
Okay.
You know what? I'm just gonna ask ChatGPT. How did they used to cure?
Wait, what?
How did they?
You were supposed to have the answer, you weirdo.
Oh, I did, but they're about to confirm my story. How did they used to cure women's hysteria at the turn of the 20th century? I just need the quick answer. What is it?
Dude, no, I found it. Ah!
Oh, are you going to read your response at the 20?
No. You do what you want, but no, I'm good.
At the turn of the 20th century, female hysteria was considered a legitimate medical condition characterized by symptoms such as nervousness, irritability, anxiety, insomnia, sexual frustration, faintness, and a tendency to cause trouble. Physicians commonly treated hysteria by inducing hysterical paroxysms, essentially orgasms, through pelvic massages. Doctors manually stimulated the genitals until patients experienced relief. This process, considered medical rather than sexual, was widely practiced and socially acceptable. There it is. What do you think of that, Lauren?
I have to go to bed, Omar. I have some Korean thieves to get to. Thank you for that.
You're welcome. The more you know.
I'll be sure to share it with your dad.
Oh, well, I just let me know if he is the one that caused you to swing the other way, because that's the running joke.
Are you asking if your father made me a lesbian?
Did he turn you gay?
Did your father turn me gay?
Yeah.
How old do you think I am?
42.
So close, bro.
I know you're 32, Lauren. I always bullshit you with your age.
So do we really think that?
No, we should not go into any further details because you're going.
Well, you're the one who instigated this scenario, and I just want to tell you how perverse I think you are at this time. Because when I make sex jokes about your father, they're tasteful and of age. All right, so
I mean, it didn't have to be like some kind of a weird thing that. Never mind, Lauren. You've ruined the story. You've ruined the premise.
Just give up.
I give up. I give up. It's too late. It's like it's not even. It's like gonna be 11, and I've had a couple of days, man.
All right, that's fair. That's fair, and it's 1:48 here, so I gotta go and
nice.
write
What time do you get up anyway?
It depends on the day, honestly. I'll probably get up in about 5.5 hours.
Oh, well, that's a good measure of sleep. Is about what I get.
Yeah, unless you've gotten 4 hours of sleep the night before, and that sucks. But
yeah,
shit happens.
Not good. All right, Lauren, let us sign off so we can go to bed.
Yes, please. All right, bye. I'll talk to you later.
Bye-bye.
Oh, wait. Sorry, I missed the start. Redondo Beach, thank you for the 2. It's a new one, LOL. Oh, okay. Your email? All right. Thanks, guys. I am going to take off now. I wonder if Omar's chat can still see me because our streams were linked. If so, tell him he's a dick next time you see him. Bye.